Yes, just one moment, Mr. Butler. Actually, I have all the stationery I need. I have. Okay. Yes.
My Lord, could I pick up on the issues that were raised yesterday? The first point is that could I add something to the answer that I gave to my Lord Justice Warby. You asked yesterday whether it was an aim of the scheme to replicate the world of work, and whether requiring claimants to find money up front for childcare promoted that. And I gave my Lord two answers yesterday. First, that this wasn't part of the justification advanced by the Secretary of State. And second, that replicating the world of work wasn't an aim of the scheme, but was a means of achieving the aim of incentivising the transition from benefits to work. That was the answer I gave yesterday. But there's also a third point, which I should have made, and this is just a factual point. If you fall out of universal credit because your earnings are too high, then there is a different state benefit that becomes available called tax-free childcare, which is another way by which the state subsidises childcare costs.
You may know, Mr. Butler, that I did a case about the introduction of tax-free childcare and the scheme that it replaced.
My lady may recall that unlike universal credit, that benefit is paid up front.
Yeah.
And could I just to vouch that point, could I please show you one passage in the evidence? It's in volume 1 of the supplementary bundle. Tab 2. This is the witness statement of Kate Lawton, who we saw is from Safe Children. And if you could please turn to page 227 of that statement. You'll see an explanation of tax-free childcare at paragraph 19.
It's a very different scheme, isn't it? Because it's paid directly to the provider.
Yes. So the only point I wanted to make is that the proof of payment rule doesn't replicate the world of work that you face when you come off universal credit.
On the contrary.
On the contrary, because when you come off universal credit, you receive a different childcare subsidy, and it's paid up front.
And there's an earnings cap on that, I think.
Well, then there must be. I don't have the figure to hand. I think as I said,
There's a limit on the credit, I think.
Footnote 9. I don't know whether that's the same provision. Do we know?
I think it's 100,000, isn't it?
Yes, exactly. We think the
Yes,
cap is that
right.
neither parent can earn more than £100,000.
Quite a high cap.
So that was just to add to the answer that I gave
Thank you.
to that question. Then, my Lord, the Vice President asked the question whether age is a suspect ground.
Yes.
There's a very clean answer, and the answer is no, and one finds it in volume 1 of the authorities. At tab 26. Final tab. Page 888. And the answer's at paragraph 78.
Yep, okay, thank you. Don't get more succinct than that.
Yes. Then I was asked why the department rather than the minister was the defendant in Brewster.
Yes.
The subordinate legislation that was reviewed in Brewster was the 2009 pension scheme regulations. And those were made under, this is all in the judgment, they were made under the Superannuation Order 1972, quite an old primary order. And at the time that regulation making power was made, there was no such thing as a Minister for the Environment in Northern Ireland. By the time the 2009 regulations were made, the thing that was reviewed in Brewster, there was a minister who was responsible for the department. But because the regulations were made under the 1972 order, they had to be made in the name of the department.
So the 1972 order said, I mean, it's not something I've ever seen in English legislation, that, well, who did it say was the regulation? I've never heard of it. What is a department?
So when one looks, well, I haven't gone back to the 1972 order, but what I have done is to look at the 2009 regulations. And when one goes to the end of the regulations, where one would normally find the minister's name,
Yes.
one sees the departmental stamp made by Benny.
Right. Well, there you are.
There we are.
If I'm sure your junior's got nothing better to do, but I wouldn't mind seeing what the 1972 order actually says.
Of course. Could I just give authority as to why it doesn't
It
matter?
no. I'm sure it may be something to do with the special arrangements in Northern Ireland.
Yes, I'm sure that's right. But the reason it doesn't matter is because the principle that's set out in Brewster was adopted in the Court of Appeals analysis in SC as a generally applicable principle. If you want the reference to that, it's Volume 1, Tab 21, page 708, paragraph 93. It's general principle applicable to the standard of scrutiny is whether or not the decision maker had regard. That's obviously subject to the carve-out that we see in the Supreme Court, that you don't apply that approach to primary legislation. So that was the third point. Could I then please hand up a couple of additional documents to deal with the other points that were raised? Three sets there. So these are to be, if you be so kind, just to slot them into the additional bundle that I handed up yesterday.
Thank you.
Yes.
And what you've got is you've got a replacement index, which indicates new item 4 and new item 5.
Just a moment. Sorry. One day all this will be electronic, but not just yet. Need my Lord's generation rather than mine. Right, okay.
And so there's a you should already have blank tabs 4 and 5. And so
Was that just intelligent guesswork?
that was fortuitous, yeah. So the table goes behind tab 4, and then the other two bits go behind tab 5.
Yeah. Yes.
So tab 4 is the table we produced overnight to show what we say is a clear and consistent line of cases in which Strasbourg has required weighty reasons in indirect discrimination cases.
That will be very helpful. Thank you so much.
As I'm going to show you in a moment, the Strasbourg court doesn't apply the label of direct or indirect discrimination, but these are the cases in which applying UK labels, they would fall under the into the indirect category.
It's a bit more complicated than that, isn't it? They've begun to use it rather unsystematically.
Yes, that's more accurate.
Yeah.
So I'm not proposing to go through those. The point is already made by Lord Reed that Strasbourg has applied the weighty reasons
Thank you.
requirement. Could I then please deal with AM Somalia?
Yes.
And if I could deal with that by reference to the note, which I hope you slotted into tab 5.
Yes.
And so, as the court has seen, in AM Somalia, the Court of Appeal said, paragraph 61, that the weighty reasons approach doesn't apply to indirect discrimination.
Yeah.
That was then applied, that passage of AM Somalia was applied by the Court of Appeal in Burnett. They said it's not weighty reasons, therefore it's the standard proportionality approach. That was then followed by the Divisional Court in MA.
Yeah.
And Lord Justice Laws in the Divisional Court said that what the court meant in Burnett when it said the standard proportionality approach was manifestly without reasonable foundation, because that was the prevailing approach in the socio-economic sphere at the time. MA in the Divisional Court was then appealed to the Court of Appeal, and that's the authority that you've got immediately behind this note, which I'll come to in a moment. That then went to the Supreme Court, which you've got that judgment of tab 15. And in both the Court of Appeal and the Supreme Court, the manifestly without reasonable foundation test, in inverted commas, was applied. And it was that case then that went to the European Court of Human Rights and became JD and A.
Yes.
And as we saw yesterday, the European Court says not manifestly without reasonable foundation, weighty reasons, where indirect sex discrimination.
And I think the next para answers this, but just in case it doesn't. In a situation where authority by which we are bound, whether Court of Appeal or Supreme Court authority, appears to be inconsistent with subsequent Strasbourg authority, it is only the Supreme Court that can lift the burden of following precedent from us.
Yes.
You're about to show that
Yes, why it's
it does.
overruled. Yes, the domestic doctrine of precedent requires you to follow, you're required to follow the domestic doctrine of precedent in preference to having regard to what Strasbourg says.
Yeah.
But the point of this, the next paragraph, I hope, supports the point that I'm going to try to make, that what the Supreme Court does in SC is applies the European Court's line of case law, including JD, and the important point, what one has to remember when one is reading the concluding passages of Lord Reed's judgment is that SC is an indirect sex discrimination case. That is the context in which the conclusion is drawn. And so in the context of an indirect discrimination case, Lord Reed says the intensity of the court's scrutiny can be influenced by a wide range of factors. In particular, very weighty reasons will usually have to be shown if a different in treatment on a suspect ground is to be justified. But other factors can lower the intensity. And then 159, it's therefore important to avoid a mechanical approach based simply on the categorisation of the ground of the difference in treatment, the court should generally be very slow to intervene in areas of social and economic policy. But, as a general rule, so all other things being equal, differential treatment on grounds such as sexual race nevertheless require potent justification. So that is the Supreme Court's judgment in the field of indirect sex discrimination. And so that overrules all of the previous case law on manifestly without reasonable foundation as ousting the distinction that's drawn in relation to suspect grounds in the context of indirect discrimination.
Can I just, it's really just for my own clarity of thinking, in case you help on it. I've always found it slightly confusing coming from an employment background. But in public law, people talk about grounds of indirect discrimination. To me, grounds means what motivates the discriminator in direct discrimination cases. But it's quite widely used, and this would be an example in non-employment cases, to mean, I can't quite find another word for it, but
basis, I think, probably.
Basis might do. I think perhaps basis is the best, but it connotes the status which is disproportionately impacted by the. But I think if we were starting from scratch, we wouldn't use grounds because of this confusion.
It's a bad term, I agree. But I suspect the reason that Strasbourg uses that terminology is because of the wording in Article 14 itself, which talks about on the ground of. But my lord, I absolutely agree. It's not a particularly apt way of describing indirect discrimination. So my submission is that the DSC overrules AM Somalia on that point. But can I then come back to the point that I kept coming back to yesterday, which is really the question is, did Mr. Justice Chamberlain err in his approach? And actually, his conclusion on the significance of status is very modest. And one sees, I've set it out at the bottom of the page, that all he says is that the group, so he identifies, as I showed you yesterday, he identifies 3 contextual factors as a matter of principle, and then comes back and looks at them in the context of this case. And the first of those contextual factors is the ground, in inverted commas. And he says the group which is subject to disproportionately prejudicial effects is defined by reference to gender in this case. This means that more convincing and weighty reasons will be needed than if the discrimination were on another non-suspect ground. It's an entirely uncontroversial proposition.
Well, although it's very modestly stated, there's an argument that it was wrong at the time it was said if you took a strict view about the effect of what starts with AM Somalia. But he anticipated what the Supreme Court was going to say, and certainly you can say it's uncontroversial now. Now you can say it's rather an understatement.
Yes, if anything, there was the judge shouldn't have said that he was applying manifestly without reasonable foundation and should have applied a stricter test. Absolutely, but that's for me that's an a fortiori point.
Right. Well, thank you.
Could I just make one more point, which may help on this? If you could please look at MA in the Court of Appeal, which is the authority it's satisfied. I won't set it all out. I mean, you've seen that it's an indirect, well, at least MA at this stage is an indirect disability discrimination case in relation to the bedroom tax. And then linked up with the indirect sex discrimination case in the Court of Appeal and in Strasbourg. But if you look, please, at paragraph 46, which is at internal page 600. part of the judgment of Lord Dyson. I think perhaps if I could just leave you to read paragraph 46.
Yeah.
And so I think this is really a point, a submission that would be made in the future if the court were being invited to take a new path in relation to direct versus indirect discrimination, the kind of distinction that Lord Reed contemplates but doesn't make when he refers to the US Supreme Court. And what one might say is, well, it's not a very appropriate distinction to draw for the purposes of Article 14, because that's not the way that Strasbourg looks at Article 14. And of course, context is very important when identifying the standard of scrutiny. But the decisive contextual factor is not the label of whether it's direct or indirect, it's the circumstances of the case and the severity of the consequences of the discriminatory treatment.
But to some extent, that's an aspect of Ms. Dobbins' submissions. She says, perhaps this was something you're going to come to, in which case I'm happy to wait, that however you label it, there are different sorts of discrimination, whether direct or indirect, against women, and that it should be more difficult to justify ones which reflect stereotypical assumptions than ones which reflect, I'm not quite sure how she put the things that are easier to justify, but I assume it's something like socioeconomic history, which has resulted, without the decision maker having any assumptions, in women being disadvantaged or more vulnerable to the effect of whatever the measure is.
Yes.
And in some ways, if we're going to be free of the shackle of direct and indirect, it all just goes into the soup. That's not an unattractive submission.
I have no objection to it. It's a contextual factor. But it formed no part of the Secretary of State's case below, and there's no error in approach by the judge. Now, if this court were to identify some error in the judge's approach and to embark on the proportionality assessment afresh, then I would have no objection to this court having regard to all of the relevant context when deciding on the standard of scrutiny. But coming back to the point which I made a moment ago, given that the judge was applying a manifestly without reasonable foundation threshold, albeit a context-adjusted one, it's difficult to see how, if he were freed of the shackles of manifestly without reasonable foundation, he would conclude that the rule were proportionate.
Well, that's why you say it's an a fortiori point.
Exactly. Unless I've missed something, that was my response to the questions that were raised yesterday.
Yeah, thank you very much, and thank you for a certain amount of midnight oil, which will have been burnt either by you or your junior.
Well, I'm
both.
very grateful to Ms Jones. It was her midnight oil. I was looking yesterday at the Secretary of State's submission that it was impermissible to look at whether the decision makers had confronted the problem. And I took the court to Brewster for the proposition that that is relevant, a relevant factor to the margin of appreciation. And that I also showed you TP and AR in the Court of Appeal to show that the absence of consideration may also explain why the Secretary of State is unable to advance substantive justification. Simply that if the thing wasn't thought about, there's less likely to be the material to demonstrate that it's proportionate. Could I then come to the final part of my submissions on justification and return to something that we touched on yesterday, which is the distinction between aims and means. This is illustrated by the case of Langford, which is in Authorities Volume 1.
Yes, which tab?
Tab 22. This is a judgment of the Court of Appeal in a challenge to a rule in the RAF pension scheme. The judgment applies DA and the manifestly without reasonable foundation test. So that bit of the judgment can now be seen to be wrong. But the bit that I'm concerned with, aims and means, remains good law in my submission. And that is at page 740. And what paragraph 36, Lord Justice McComb is citing Brewster, but he, if I may say so, illuminates the point too. The first sentence of paragraph 36, he says, "To my mind, the aim of this scheme, the pension scheme, is to put those in stable and exclusive relationships with scheme members, whether married to scheme members or not, into the same position for benefit purposes." So the aim of the scheme was to extend benefits to unmarried partners. And then in the fourth sentence, beginning the exclusion of partners, he identifies the rule which was formulated to give effect to that aim. So he says the exclusion of partners of deceased scheme members, this was the exclusionary rule that was under challenge, who are still married to third parties, is one method or means of identifying the target group of dependent beneficiaries. It's not an aim of the scheme itself. So you've got the aim, you've got the rule, which is the means, and then the critical point is the fifth sentence, where he says, as Lord Kerr said in Brewster, one must not confuse the aim with the means employed to achieve it. And then he cites a passage from Brewster. Could I just ask you to note in particular at letter H on that page? This is Lord Kerr. He says, the error of Denny's submission on this point, and with respect Lord Justice Higgins' characterisation of the aim of the regulations on this respect, is to confuse the aim with the means employed to achieve it. Permitting some cohabitants in certain defined circumstances to obtain the same pension provision as married or civil partner survivors is the way in which the unjustified discrimination is avoided. It's not an end in itself. The essential question, therefore, is whether imposing a nomination requirement, which was the rule in issue in Brewster, in fact conduces to unwarranted difference of treatment or to its removal. In other words, does the rule promote the aims of the scheme or undermine them? And that's absolutely crucial when one works through the Bank-Mellett test. because one begins by asking whether the aims are justified. Then one asks whether the means are rationally connected to the aim. Then one asks whether the means, if they have adverse effects, could be ameliorated in a different way which doesn't undermine the aim. And then one moves to fair balance. So it's crucial to have in mind through that analytical process the distinction between aims and means. And the fundamental problem with the proof of payment rule, as identified by Mr. Justice Chamberlain, was that it served to undermine a central aim of the scheme. The scheme was designed to get people into work, and the proof of payment rule was a barrier to work. That's all I was proposing to say about justification, unless
Well,
there are questions.
What do you say about the another leitmotif of Ms. Dobbin's submissions, that it is also an aim of the scheme that it be straightforward and easily workable, and whether this is a separate aim or part of it, that it minimise the opportunities for fraud or error,
Yes.
error being the real point,
Yes.
more than fraud. And what is said, which I'm bound to say seems to me to have a fair amount of force, is that the most straightforward way of seeing that people who've incurred childcare costs to get them back, or 85% of them back, is to find out what they have paid and pay them promptly after that. Now, that surely is also an aim of the scheme.
Yes, I accept that. I accept that what my Lord identifies, that the scheme be easily workable and that it minimise fraud and error, are co-aims of the scheme alongside making work pay and encouraging people into work. And I accept that they're legitimate aims. But when one comes then to the third limb of Bank Mellor, whether a less intrusive measure could have been used without unacceptably compromising the achievement of the objective, one could change that to objectives in this case. And I appreciate there needs to be then a certain amount of balancing. But one asks, well, does the proof of liability rule unacceptably compromise the achievement of those objectives? Well, no, because it works perfectly well in relation to the housing element, and there's no logical reason, as the judge says, why it couldn't also work effectively in relation to the childcare element. But one also then has to ask oneself, alongside the adverse impact it has on individuals, actually the key point here is the undermining of another of the central aims of the scheme.
Can I ask a question about the comparison with accommodation? I was musing yesterday on your construction of the regulations to avoid the undesirable effect that is contended for by the Secretary of State.
Yes.
Have I got this wrong? If the claimant for universal credit for the childcare element has a scheme which is based on the production of an invoice, liability basis. And is therefore claiming in advance of receiving the childcare. Would there not be an incentive for that person to estimate the maximum possible childcare that he or she would conceivably want in the period in question, seek and receive payment on that basis, but then perhaps receive much more, depending on how things actually turned out, than was due for the childcare received. Because there might be all sorts of reasons why a perfectly good faith estimate made in advance turned out not to be the reality. And on your construction, the taxpayer would fund that.
So does that amount to the parent over-contracting for childcare?
Yes.
Just in case it's needed?
Yes. I mean, it would be a natural thing to do. A precautionary approach would be natural because, particularly if you know that your any error in your estimate will be funded by the taxpayer and not by you. So that this was a thought that occurred to me yesterday as a possible consequence, not of the Secretary of State's approach, but of yours.
Could I attempt to give three answers? The first is the same as I gave my lord yesterday.
I know.
Which,
I thought it would be.
Which you'd anticipated, which is that this isn't the justification advance.
I know. But this, I think this construction point doesn't seem to have been an issue below. But maybe I'm wrong about that.
It could also be said, couldn't it?
But you're quite right. The first answer is the obvious one.
But there's a possible answer to the first answer, or at any rate a shading of it, which is that in the broadest sense, the administrative simplicity on paying on receipts comprises all sorts of sub-points, including this one.
Well, in the loosest possible way, it seems to me to be a rather different point.
Okay.
So my first, I've said I've got three answers.
Not the Secretary of State's case.
The first was no, that's not the justification advance. And of course, it's for the Secretary of State to advance justification, not for the court to divine it. The second point is that the hours contracted for have to relate to work in the same way as currently the proof of payment can only be proof of payment 4 hours of childcare while you're working.
Yes.
But in relation to the current system, as I showed the court yesterday, that depends on trust at the moment, subject to spot checks. It's left to the parent to declare that the hours that are being claimed relate to the hours of work. So there will still be that requirement, which would impose some discipline on the process. But then the third point.
So I'm not sure. Can you just say that again? I haven't quite internalized it.
Yes. So on the current proof of payment system, if one claims 20 hours of childcare in relation to 20 hours of work, the system will be able to see. Well, the system will be able to see if you had claimed 25 hours of childcare, but you only worked 20 hours. There'd be an obvious mismatch. But what the system can't tell, if you've claimed 20 hours or 20...
Yes, this is the point you made later.
Point I made later.
Childcare to go to the cinema. Yeah.
Exactly.
Yeah.
I've
got that, but I wasn't sure how that fits into...
Well, so the current system requires honesty and self-discipline and honest reporting to the Secretary of State. And that would also apply in the proof of liability scheme. And so this potential problem of, well, I'll just take everything I might conceivably want, but not actually honestly have in mind that I need it for the
I don't think my lord was necessarily suggesting that there was anything dishonest about it.
No, I wasn't. I think I'm not suggesting that there would be any difference, really, in the incentives to dishonesty.
No.
I'm suggesting that because we know from the evidence that the nature of childcare need is fluctuating wildly
Yes.
and at quite short notice.
Yes.
I mean, that's actually common knowledge. We don't need evidence for that.
Particularly if you're on 0 hours contract.
Not so accommodation.
Yes.
You need that all the time.
Yes.
And therefore, it's quite plausible that, quite honestly, the person would say, well, I might well need 40 hours. And if I do need 40 hours and I haven't contracted for it, well, I'm going to get stuck. I won't get paid.
Yes. So
that's what I'll bid for. And then, if for all sorts of reasons, there are all sorts of reasons why the work pattern may change. They're on a 0 hours contract. They get called in to do some work unexpectedly, or they don't get called in when they expected to. So they use up less than they thought they might. And so there's a reconciliation task to be done, and therefore possibility of error.
Well, the current system of paying upfront for the childcare and then claiming it back would lead to the same approach. So if you're a parent who is paying for next month's childcare and then submits the invoice to the Secretary of State in respect of that childcare, of course you're not going to be able to get that money back until after the childcare has been provided. But what you're paying the childcare provider for, and what you'll be submitting to the Secretary of State, will, in exactly the same way, be based on your anticipated need for childcare.
Not always.
Not always, but on the footing that 90% of childcare providers require advance payments, typically on a monthly basis, then the situation is identical in the proof of payment and proof of liability rule. Could I give one more answer?
Which may be why the Secretary of State isn't relying on my point.
Which is exactly, yeah. There may be other answers. I'm trying to respond on the hoof, but there's
another answer is that
the
because
15%.
the whole premise disappears if Ms. Dobbins' construction of the regulations is right, because you'd always be able to claw back the money.
Yes. Well, that's quite so.
It's only a problem on your construction.
Only a problem on my construction. Well, I hope I've explained why we say
it's a problem.
It's not a problem. There is another answer, which is that there would be a handbrake on taking that approach, which is that the Secretary of State only pays back 85%.
Yes. Yes, so the claimant would always be under a liability to pay the remaining 15% of the costs, and wouldn't be able to get those back at the taxpayer's expense if it wasn't used.
Come what may. Yes.
So, thank you.
So that was justification. Could I then turn to rationality, which is my fifth topic?
One more point just on justification. You've explained very clearly how, on your case, this has a tendency, structurally, inherently, has a tendency to undermine the aim of getting people back into work or into more work. But I think I'm still right in saying, unless I missed things you were submitting yesterday, that we really have no way of quantifying the extent to which that tendency operates in practice. We know it operates in some individual cases because we got evidence of them, both the individual cases people have actually given witness evidence, but also the anecdotal cases, and I don't mean that in any way pejoratively, but nevertheless the anecdotal cases referred to in some of the evidence produced by the stakeholders.
Yes.
But those could still be, frankly, a handful of cases, because it is so unpredictable how this will hit people, because it's so dependent on the availability to them of other resources. By definition, these are people with modest resources, but the sums involved may also be quite modest. Depends how long in advance people want to be paid, how many weeks, and so on.
Well, I'm not sure I agree about that, because we have got data on that, and we can see that actually the payments are really very significant. If one's paying for a month in advance in the summer, for childcare, one's talking £800 or £1,000.
Yes, okay, well, remove that part. I don't think that's a complete answer, but I take the point, though sometimes it will be figures of those amounts. I think that it really is the case that he's just, although this is a real effect, there is no way on the evidence, and might not be even if everyone had pulled all the stops out for evidence, really ever to quantify how big the effect is.
No, that's quite so, but that's also, that's a very common position in Article 14 discrimination cases. And one of the observations which the judge made is that although there isn't that kind of hard data to say X thousand working hours are lost per year as a result of this rule, there was much better evidence in this case than one often finds in Article 14 cases, not only because there were a number of individuals whose circumstances illuminated what is clearly logically a structural issue, but also because you have the main charities in this field, among them Save the Children, but then as the judge also pointed out, the Child Poverty Action Group, entirely outside of this, long before this litigation, so it wasn't a self-serving statement, told the Select Committee that this was the biggest problem. Now, of course, that doesn't quantify it. I entirely accept that. But in my submission, the court can be satisfied that it is a real and substantial problem.
Yeah, fair enough. Well, I just really wanted to pin that down and get your answer to it. Thank you.
So rationality. As the judge pointed out at paragraph 175 of his judgment, the intensity of the court's review of reasonableness will vary according to context. That's an uncontroversial proposition. It was stated by the Supreme Court in Kennedy. That's the authority that the judge cites. And that operates, that sliding scale of scrutiny, depending on context, applies in a similar way to the standard of scrutiny in relation to proportionality. And that point is underscored by Lord Reed's analysis in SC. We could please turn that up again. It's in volume 2, tab 31.
Oh, sorry.
At page 1088. I could ask the court please to read paragraph 146. So one sees at the end of the third line from the bottom that Lord Reed says the same is true of the convention test of proportionality. So he's drawing parallels between the two approaches, and one might say that Lord Bridges' statement in the Hammersmith and Fulham case is akin to the manifestly without reasonable foundation threshold, but that has to be balanced against other factors in exactly the same way as a balance needs to be struck in relation to the standard of scrutiny in relation to the proportionality exercise. Could I then please turn to Johnson, which is tab 23 of this one, volume 1 of authorities, tab 23. Okay, can I make it clear what I'm not relying on this authority for? I'm not suggesting that there is any factual analogy between Johnson and this case. And I accept that Johnson is clearly not authority for a general expansion of rationality review in the sphere of universal credit or anything else. The reason I'm showing the court Johnson is because in my submission it helpfully identifies some of the factors that are relevant to the standard of scrutiny in relation to rationality.
Just before you start that, I was just looking at the list of authorities cited. It doesn't appear to include Hammersmith and Fulham. Anyway, it's just an oddity.
Yes, nor so as my Lord will recall, the challenge related to the Secretary of State's refusal to fix a quirk of the universal credit system that my learned friend described yesterday. And the Court of Appeal applied the well-trodden formulation: was the decision outside the range of reasonable decisions open to the decision maker? And if you could please look at page 771. At paragraph 50, Lady Justice Rose identifies a number of the factors that are relevant. So she identifies the disadvantages if the problem isn't fixed, the disadvantages that fixing the problem would cause, and then importantly, this is one of the points I place emphasis on, whether a solution would be consistent or inconsistent with the nature of the universal credit regime. And then also, had a reasonable balance between these factors been struck? Now, in my submission, those factors echo some of the factors that have to be assessed as part of a proportionality exercise. As one would expect, following Lord Reeve's observations in SC. And then if we could please turn forward to page 785. There is a heading towards the bottom of the page, Other Factors. Paragraph 92. Other factors I consider relevant to the rationality of the ongoing decision not to create an exception to allow for the non-banking day salary shift are size of cohort, duration of the impact, the arbitrary occurrence of the event, and then the bit I emphasise, D, the inconsistency between the effect of the problem and the aims of the universal credit regime. And if we could please skip forward to page 787. At paragraph 100, we get the analysis in relation to that last factor. So the title is Disincentivising Work. It's common ground that the legislative policy behind universal credit in general, and Section 8.3 of the WRA and Regulation 22 in particular, is to encourage work by being responsive to changes in earned income and making work paid to the fullest possible extent. That's the aim I rely on. There have been many ministerial statements to that effect in policy documents and orally to Parliament. And then if we look, please, to the last 4 lines of that paragraph, the evidence of Mr. Cooling on behalf of the Secretary of State also stresses that the objective of incentivising work, both as a way of alleviating poverty and as an outcome in itself, was a fundamental tenet of the new scheme. And then overleaf, at the bottom of the page, next to letter H, there is a passage which begins, Lord Justice Longmore cited Lord Kerr in GC. This is talking about the Padfield principle as applied by Lord Justice Longmore in the Rights of Women case. And if I could please ask the court to read from there to the end of paragraph 107.
So the point is that if one was looking at a Padfield challenge, it would simply be open to say that the aim of the statute is X. That objective is not being achieved by the way in which the minister has implemented whatever the regs are.
Yes.
And it's enough for there to be the disjunct. Whereas in a rationality challenge, it's a factor, maybe a powerful factor, but there may be countervailing factors.
That's right. With the benefit of hindsight, we might have brought a Padfield challenge.
Yeah.
But it is proper, as my lady says, it's properly a factor which feeds into the rationality analysis.
Because, I suppose if you're standing back and looking at it from the perspective of rationality, where you've got a mix of aims and objectives, it may well be that the balance is struck in a way which, let's say, for a minority of very unfortunate people, creates a hardship which would strike against the implementation of the major aim, but nevertheless be proportionate, yes, because other aims are promoted by doing it that way.
Yes. Yes.
Yeah, I see.
Could I, to take the point a little bit further, please show you the judgment of my Lord's judgment at page 790. And at letter H on 790, my Lord says that for those reasons I fully accept that a court should avoid the temptation to find that some particular feature of such a system is irrational merely because it produces hard, even very hard results in some individual cases. So one really needs to have a principled basis for identifying the irrationality. And then over leaf, my lord identifies certain features of the scheme, that it was entirely this problem was entirely predictable, it has an arbitrary effect and affects very large numbers. But then if one looks at letter D, in my submission one gets to the nub of it, which is that if anything, the present operation of the scheme runs positively counter to its declared purpose. It follows that I can't accept that there's no way in which an appropriate adjustment can be made without prejudicing the overall statutory purpose.
Yes, I mean, but read when it says it follows, it doesn't just mean it follows from the last sentence. It means it follows from everything else I've said in that.
No,
paragraph.
of course.
No, sorry, but I just thought I'd.
Yeah. And so on. And then paragraph 115. I'm inclined to agree with Lady Justice Rose that the relevant form of unlawfulness is best characterised as irrationality. I also agree that it has echoes of the Padfield principle. And this, if I may say so, I respectfully agree with what follows. But ultimately, these various characterisations are simply aspects of the fundamental question of whether Parliament can have intended the rule-making power to be exercised in a way which produces so arbitrary and harmful an impact on the respondents and the very many claimants who are in the same position. So one can ask the same question. When Parliament has conferred on a minister a rule-making power, one could strike down a rule under the Padfield principle if it's contrary to the purpose of the legislation. But one can also ask the question, is it a reasonable exercise of the rule-making power to use it in a way that cuts against one of the overarching aims? So you can frame essentially the same point under the Padfield principle or under the principle of rationality. Now, I think I would accept that it may be that thought that the unlawfulness which is identified in our case, or submitted in our case, is closer to the Padfield principle than the situation in Johnson, because we're talking about the making of a rule rather than the refusal to fix a problem post hoc. But in my submission, that can still probably be characterised as irrationality, the irrational exercise of the rule-making power.
I must say that whilst I understand the conceptual basis for saying that if you find that something is disproportionate, it's like or unjustified under Article 14, there's a chance that it's irrational at common law as well, and the two may actually overlap or dovetail. But on classic irrationality principles, I do struggle, bound to confess, with the proposition that where you have a rule which to an extent may cut across the aims for a particular cohort or members of a particular cohort. In other words, it's likely to produce harsh results for some people, which is not good enough in itself.
Yes.
But is otherwise within the range of mechanisms that would be open to a reasonable decision maker.
Well, that's the question.
Yeah. That's the $64,000 question,
yes.
Isn't it?
It doesn't. I absolutely accept it doesn't follow.
Is it per se irrational? Because at the moment it doesn't strike me that it is per se irrational to say, well, we'll have a simple system which means you show us that you've paid for the childcare and you get back what you paid. It's simple. We know exactly how much you paid out. It's done after the event. We'll pay you fairly quickly. The fact that it might create harsh results for one or two even 2,000 members in a group doesn't necessarily make that perverse.
No, and it's no part of my case on rationality.
No.
That it's the adverse impacts on the group
No.
that are what make the exercise of the rule-making power irrational. My point is that the minister is conferred a rule-making power for a purpose. You don't look at the question of whether the rule is a sensible one in a vacuum.
No.
It has to be judged against the purpose for which the power is given. And the purpose for which the power is given is to promote the legislative aims.
Yeah.
And so if the rule-making power is exercised in a way that cuts against and undermines the legislative aim, I'm talking theoretically at the moment,
Yes.
rather than by reference to the facts of this case, and there was another rule which wouldn't have cut against the legislative aims, then that would be an irrational exercise of the rule-making power.
Would it not be a question of fact and degree?
Well, it would be a question of fact and degree. If it was not significant, or if there were matters of fine judgment as to whether the alternative was genuinely viable, then yes, one might say that it wasn't an irrational exercise. But in my example, if one has a situation which, for the sake of argument, is a clear cut, you're undermining an aim, you're not promoting another aim any more than another rule you might choose, can Parliament be said to have given you the power for that purpose? Well, no. You don't have the freedom to make rules which just, well, are perverse in the sense that they undermine the aim of the scheme.
Well, we probably explored this aspect as much as we can.
Yes, could I just try and tie it then to the facts of the case? So in our submission, the rationality challenge can be pared down to two essential propositions. First, is the proof of payment rule in any way necessary to promote the aims of the scheme? The legislative aims of the scheme. And on the evidence and argument before the judge, it isn't. That's what the judge found on the material before him. And then second, does the proof of payment rule undermine an aim of the scheme? And the judge found, yes, it's inimical to a central aim of universal credit, indeed the aim that's identified in Johnson. And if those two propositions are right, then we ask rhetorically, how could promulgating a rule of that kind be a reasonable exercise of the rule-making power? And one can attach all of the understandable caveats and caution that is attached in Johnson. This isn't opening the door to a wider approach to rationality. It's not suggesting that rationality will become a tool with which to beat the Secretary of State in relation to other aspects of the Universal Credit Scheme or in relation to other areas of administrative law. So those were my submissions on rationality, unless there are questions arising from that.
What's left?
Ambit and form of order. I think I can deal with those both very quickly.
Yep.
So topic 6, ambit. We say that the judge was plainly right to say that childcare comes within the ambit of both Article 8 and A1P1. In relation to Article 8, what the judge did was to apply the ratio of the Court of Appeal's judgment in SC, namely whether the benefit is a modality of the exercise of the right guaranteed by Article 8. And he cites the passage of SC. And then in relation to A1P1, the judge again applied the ratio of the Court of Appeal's judgments in SC, which is simply an application of the well-trodden formulation in Steg, whether but for the condition of entitlement under challenge, the individual would have an enforceable right to the benefit. If we take away the rule under challenge, would the individual get it? And both those ratios that were applied by the judge...
Hang on. If you took away the rule under challenge and had a proof of liability rule, well, A, we don't know what rule you'd have instead, but you're assuming you'd have a proof of liability rule. We can't say for certain it's not as nightfall as days they get it either.
Well, no.
There will be fewer difficulties.
One has to take a realistic approach to the Steg test.
Well, I'm not sure one does. I mean, it may sound... this is about property rights. That's what A1P1 is about.
Yes.
That's why I think a very hard-edged approach is necessary.
Well, the situation, the situation that's being contemplated is somebody who has contracted for the provision of childcare, but is unable to pay the payment up front. The rule under challenge is impeding that individual from getting paid by the Secretary of State. If in that situation one takes the rule away, the individual gets paid.
It's impeding, but not preventing.
But I mean the term. I mean to use the term to mean the same thing.
You don't need A1P1.
I don't. It's enough for me to get within Article 8.
In the ambit of Article 8.
Yes.
And SC in the Supreme Court just endorses your position.
Oh, well, absolutely. So having applied the ratio from SC in the Court of Appeal, the Supreme Court then endorsed the Court of Appeal's approach. So there can be no doubt that the judge correctly directed himself. No error of approach. And we also say that his application of the facts to the ratio in SC was unimpeachable. He identifies, by reference to the white paper and other material, that part of the philosophy of universal credit is to inspire family life in which parents work and set an example for their children. And so it's designed to facilitate the form of family life which the state seeks to promote.
I suppose, sorry, coming back to A1P1, which I'm not sure you want to spend a lot of time on, but in fact the point I put to you may not be a good one, because I was thinking of this as conventional judicial review, and we're looking at the tendency of the rule as a whole.
Yes, someone's not looking.
You say that on the facts of your particular case, you can say this is the only difference. That's the evidence.
Yes, which is
where we're going with your final head.
Yes.
Yeah.
But that's illustrative of the problem which forms the basis of the challenge. I'm not sure it's ever been said in relation to ambit of A1P1 that the rule has to impede in every case.
No.
No.
So, unless I can take the point any further, those are my submissions on ambit. Then finally, seventh topic, did the judge express himself too widely? Now, as the court has identified, an appeal is against the judge's order, and there is no complaint about the judge's order under this limb. And so we respectfully submit that this isn't properly a ground of appeal. Now, insofar as the Secretary of State contends that the judge expressed himself too widely in the judgment, my primary point is that's not an appeal point, but it's also, my submission, misconceived. Because one has to have in mind the court's task in relation to a indirect discrimination claim in contrast to a direct discrimination claim. Now, in a direct discrimination case, what has to be justified is the difference in treatment. In an indirect discrimination claim, what has to be justified is the rule itself. And so the judge necessarily had to ask whether the rule was justified by considering its effects across the board. He had to do that. So actually his approach was unimpeachable. His reasoning was the right approach, and his order was absolutely the right form of order.
Would it, sorry, it's very basic stuff, would it follow that if the action had been differently framed, say it had been brought by a pressure group, or I'm not quite sure how you would frame it, but you actually could have got a declaration that that the rule was unlawful because it had a disproportionate impact? It'd be two ways in a sense to the same result.
Well, it's a difficult question. The approach that the court took in JCWI, which is the same as the approach the Supreme Court took in BB, which is that if one is challenging a scheme, not in the way that it applies to an individual, but in generality, then the question for the court is whether it is incapable of operating in
it plugs into all that line of authority. Yep.
So that's why it's generally better from a claimant's point of view to bring it through an individual.
But the oddity is in a case of this sort, you have to, assuming the Secretary of State has to act differently, whether by reading down the rule or simply just not applying the rule, in the case of people for whom it is a problem, and for the case of people for whom it isn't, which is a rather messy end result. But
it does create a problem for the Secretary of State. I accept that, and it's the point which I think is identified.
In practice, the Secretary of State has to resolve it by changing the rule.
Exactly. In practice, that has to happen, and the reason is that it follows that from the nature of the indirect discrimination, that if it's unlawful in respect of one woman, it's almost inevitably going to be unlawful in respect of another woman. If you were to change the rule so as to create an exception for women, you're liable to create direct discrimination against men. So it's likely to be the case, and I don't say it's impossible. It's not our concern.
No. But
it's
this is again why, as you would expect, Justice Chamberlain saw the problem and appropriately ducked it. Not for me.
Yes. This I can't.
It's not impossible, actually. One way of doing it is to have a discretionary power where there is sufficient guidance to the discretion to mean that it didn't have the effect on the women who it otherwise would affect.
Yes. Yes, that's quite right. In my submission. Yes.
And then the Secretary of State says, "Well, I don't want to have to do that because that makes the whole thing more complicated."
Yes.
Yeah. Okay.
There's also, of course, the other caveat in relation to convention cases is that the court's task is to judge proportionality on the material before it. And so it is conceivable that in these proceedings, the Secretary of State would be incapable of justifying the rule on the basis of the evidence presented to the court. But if in 6 months' time, having conducted a further study and examined the point further, it were found that actually there were real problems that hadn't been anticipated by this court in relation to a proof of liability rule, it would be open to the Secretary of State to defend another claim on a different footing and potentially to succeed on justification. And that point was identified by the Supreme Court in Cole and is also identified by the Court of Appeal in Langford. So it's not the court's conclusion isn't a forever conclusion if the circumstances change.
Yes, we've got Langford. I'm not sure we've got Cole, but
no, I think it's in the final paragraphs of Langford. If it's volume 1, tab 22. It's the final page of the authority, page 750. paragraph 68.
Yeah. Doesn't actually refer to coal, but
Well, I made the submission and it was based on coal.
I was there. Yes. Thank you.
Unless there's anything else, those are my submissions.
Well, I think only one question. She's going back to indirect discrimination. I just want to make sure I've understood this, the steps here, looking at the most conventional way of analysing the indirect discrimination in this case, which is, I think, really spelt out in paragraph 157 of Mr. Justice Chamberlain's judgment. Sure, you have it in your, sleep, but I want to have it open the same. Because it's 157 which lies behind 159 B.
Yes.
There are, as I understand it, really two steps in the reasoning. Firstly, that a median universal credit claiming mother the median UC claiming mother is bound to be earning less than the median universal credit claiming father.
Yes.
And that is based on the gingerbread statistics.
Well, it's not gingerbread statistics, it's the labour force survey, it's official statistics.
Well, all right, the labour force survey statistics as analysed in the gingerbread submission, as in was whichever, I forget whose evidence it is, but that's where we find it. It is true that actually refers to single parents. In principle, these could be, you can have both parents claiming universal credit, but that will be much less typical than the figures show, and the problem is less likely to arise in such a case in any event. So that's step one, what the median mother and father position is. Step two, if you are earning less, or the less you earn, the less likely you are to be in a position to pay fees in advance. In other words, there's a correlation between the level of earnings and the ability to pay fees in advance. I just wanted to make sure I understood how you put this bit of it. It might seem obvious, but might it be said that actually it's an unsafe inference, because inability to pay up front is not a factor of how much you earn, whether you're on the minimum wage or a pound above the minimum wage, but is a factor of how much you have saved at the time you go into the system. It's essentially a cash flow factor. And there isn't a correlation or a sufficiently safe correlation between that and general figures about earning levels. Do you see what I'm putting to?
I do understand the point. Our submission is that it was a proper inference for the judge to draw that there is likely to be, or liable to be, a correlation between one's earnings and one's ability to amass resources so as to pay for childcare up front.
To be absolutely, to have amassed resources.
To have amassed resources. There must be, theoretically, there must be some data out there, but one knows from experience that the more one earns, the greater one's savings tend to be.
No, well, I sort of see the common sense, but it's a sort of common sense that
There's not
may
a
not
linear-
follow. A lot of factors go into your resources position, and I'm not sure I want to trust my intuitive feel for this.
Well, it was the judge's
Intuitive feel.
intuitive
One he was entitled to have.
judgment, and as we saw from the authorities, judges are entitled to draw inferences of those kinds. But
Well,
of
I
course
thought that was what you were likely to say, but I just
Yes.
wanted to. I hadn't really articulated to myself, but that's a necessary step in the argument. That essentially, that women are disproportionately likely to have insufficient resources to fund the first tranche of payments at the time they go into the system, or at a time when there's some.
Certainly single women
So-
are.
single women. One can also look at
than men, also universal credit earning men, or universal credit receiving men, and fathers, but that is simply based on the simple proposition about earnings levels for single fathers and single mothers. That's the only basis for it.
Could I try and illuminate it a little more? If one can consider, hypothetically, two individuals with zero earnings, one a man, one a woman, the man will be able to get himself into a position, on average, to be able to pay for childcare and claim universal credit for childcare quicker than the woman, based on those figures. All other things being equal.
One reason, I mean, the evidence doesn't really focus on this. Even the gingerbread evidence, though it gives you and gave the judge the material, wasn't really advanced explicitly to make this point.
No.
And I think we established yesterday, and you were perfectly frank about it, that you won't find the point articulated in this way in the claim form. You said, well, it did get a bit clearer in the Stellarton argument. We didn't take us to it yesterday, but I looked at it overnight. It's not very explicit there either. I'll take you to it if you like. But
That wasn't the point I was trying to show the court in relation to the grounds. It was the suggestion that the proof of liability rule hadn't been squarely put.
Yes, I see. Well, this is almost a fortiori. There is nowhere saying, which might have alerted the Secretary of State to the need to go out and get figures about it, that women are less likely than, that universal credit receiving mothers are less likely than universal credit receiving fathers to have amassed resources such that they can take the hit at the moment they start to want childcare.
Yes. That's a fairness.
That really can't be seen in the claim form.
No.
And it can't, frankly, be seen in the Stellarton argument either.
No, I accept that.
What you say, we haven't yet heard Ms. Dobbin about this, but you wouldn't say it, I'm sure, unless it's your understanding of the position, is that this, it certainly did become perfectly clear at the hearing that this is how you're putting your case. The Secretary of State had wanted to say, help, I didn't see this coming. They could have either objected to your putting it that way or asked for an adjournment. And we can see they didn't do either of those because that would be in the judgment. But that's the way it goes, isn't
Yes.
it?
But even if they hadn't done that, even if they said, well, we were so caught by surprise, we didn't think about asking for an adjournment, this point would have to have been brought to this court
Yeah, no, you're right.
as a fairness point.
Yeah, I
As a
see that.
procedural
I
fairness
see that as well.
And there's no appeal on that basis.
But I think you will appreciate, Mr. Butler, that although we will loyally decide the case on the evidence and on the way it's been handled, we do want to get an understanding of how we got into this situation.
Yes. Could I make this point as well? I mean, not only is there no fairness appeal, but there has been no attempt by the Secretary of State. Of course, the court's power to admit evidence that arises post-hearing is narrow, But this might be one of those situations in which, if the Secretary of State had adduced new material on the footing that she hadn't had an opportunity to do so below,
Quite, but as you say, we aren't there. And actually, I mean, Ms. Dobbin didn't even put this point in her opening submissions. But as I say, we are keen to understand
Yes.
how we got to where we are.
Yes. Well, my Lord's understanding is correct.
Yeah. That's very helpful. Unless my Lord and my Lady have any questions. Yes, Ms.
Yes, could I hand up some bundles of these material that part of what you wanted. I saw the face.
I was betraying, obviously, subconsciously. I was looking forward to this eager anticipation, Ms. Dobbin. Just it didn't show.
Thank you very much. Well, I'm sorry that it's turned into one of those types of hearings where you're being handed up lots of stuff willy-nilly.
It happens.
You wanted to see the screenshot.
Yes, that will be.
So I will take you to that in a moment.
Yes.
If you wouldn't mind letting me structure my submissions in the way that I had intended.
Not only
to
let you, I
it.
encourage you to.
Thank you. I'm going to deal first of all very briefly with housing. My lords, my lady, the core point is in this appeal, housing is not an exception to the principle defining feature of universal credit that payment is made in arrears. The payment of housing proceeds on the basis that you have occupied the property. For that, see Regulation 6.4. I don't need to take you to it. But if you pay rent prior to or in advance of occupying the property, you are not going to get the housing element until you have moved into the property and occupied it. So in the example that my learned friend seemed to be suggesting to you, it's quite clear that the payment would come from a discretionary fund. And we have the manual and the guidance in order to try and cut through the technicality about that at tab 2. So this is the discretionary fund.
Mr. Butler's been given these, presumably, but in advance. Yep.
I think he was given it last night.
Thank you.
So one sees at the first page what are discretionary housing payments, and the second bullet is universal credit with housing costs towards rental liability. And then over the page, I hope you don't mind that these have been highlighted. I think that was just inadvertent.
No, it doesn't matter at all. Which page, sorry?
The second page of the guidance.
The internal page 2. No.
Sorry, 4.
Internal page 4. Yep.
And then at 1.16, you can see that housing costs includes rent in advance or deposits. And then at page 6, it explains more about this. At 4.1, the discretionary housing payment can be awarded for a rent deposit or rent in advance that the claimant is yet to move into. The other relevant passages are at 4.3 and 4.4, 4.9.
Okay, so you're, I mean, we've read the highlighted passages. Sorry, I have. So your submission is
to address the point that if it's being suggested that there is that housing is also different because you can get it in advance and be paid for it before you've actually been provided with the thing, that isn't correct.
Yeah. Okay.
And then coming to paragraph 24 of Mr. Justice Chamberlain's judgment.
Hang on 1 second. Yeah.
Where he construed the regulations that are relevant here. And accepted that it's the childcare that has to be attributable to the assessment period. In other words, it's not the charges.
Sorry, which paragraph is it?
It's paragraph 24.
Thank you.
That the key to his reasoning was paragraph 34A, which defines when charges are attributable to assessment period as those charges that are paid in that assessment period of relevant childcare in respect of that assessment period. And if one looks at 34A2 of the regulations, and I don't know if you still have those to hand, my lady. Um, 34A2 provides the formula for working out how advanced payments relating to childcare and which relate or straddle different assessment periods is allocated between them. That would obviously be unnecessary if reimbursement was just contingent on the payment of funds. And as I've already submitted, there's an important...
Sorry, you're talking rather quietly.
I'm so sorry. As I've already submitted, there's an important interrelationship between that and the cap on the amount of childcare that you can get back in a given month.
The point you made was that if you paid a large amount up front for the childcare, A, the childcare wouldn't have been provided, and B, it wouldn't be a good idea to do that anyway, because if you paid £3,000, the cap would operate on the whole of the £3,000. Whereas if you do it in tranches, 1,000, you get the cap.
You get the benefit. Yeah. Now, just coming back then to what we say is the problematic part of the judgment, it's where the judge said at 173I.
Hang on. Well, let's just do it. I don't think you took it. I don't think you took us to this, did you?
I did,
in your
but
opening?
it's really just to. It's such an important paragraph in
No,
this.
so sorry, I wasn't saying you did take us to it. I was saying I don't think you did. I haven't marked it up. 173I.
Yes, so that's the paragraph where Mr. Justice Chamberlain accepted that housing wasn't any sort of exception to the payment in arrears rule. And he obviously recognised that what was intrinsic or fundamental to both was that there would be a delay or the gap in payment. And it's that part of his judgment where he goes on to say, well, it might be possible to conceive of a regime where you can still pay on a liability basis, still be within a system of arrears, but all of that might be contingent upon what the childcare market does. Now, I'll come back to that when it comes to the proportionality assessment and how that fits in. But can I just say, that suggestion that this might all be contingent on what a childcare market does, that is at odds with the part of the claimant's case and the evidence relied on from the nursery school providers that they didn't want to wait for payments and they wanted direct payments from the government. See the evidence set out at page 452 of paragraph 5. Don't ask you to turn it up now. And obviously I'll come back to this. When it comes to direct payments to providers, which is what they contend for, that was a policy option expressly not taken up by the minister.
Indeed, which Mr. Justice Chamberlain said was an entirely rational decision not to take it up for all the reasons that were given.
But I'm going to what it demonstrates here is that there are a range of possible policy outcomes contended for by different people or organisations.
Can I just see how this fits in? This is a point you made heavily in opening. But it wasn't, as I understand it, challenged by Mr. Butler. I'm just wondering what the reply point here is.
It's about the less intrusive measure. So I will come to the point that if you're applying a conventional proportionality analysis and you can point to an obvious or clear alternative that could have been taken up instead, see that might play a part in the proportionality assessment. And I'll come to the issue about.
Okay, I mean we've obviously you've only got 40 minutes. What would help us most would be to focus on the points made by for us to know point by point which point being made by Mr. Butler you are challenging, because it's difficult for me to see where all this is going.
Okay. I wanted to deal with that because we were on that paragraph.
Yes, I see. Okay.
And obviously at that point he accepts that housing isn't an exception to arrears and that he's positing a possible alternative based on a liability system that might ameliorate the position contingent upon other factors. And in my submission, that is not part of a proportionality assessment. He isn't talking about a clear alternative course or a less intrusive measure that was.
Well, he is. He is. Surely, he's saying a liability basis.
But he's saying that whether or not that makes any practical difference is going to depend on what might happen in other moving parts of this system. For example,
When you say he, do you mean Mr. Butler or the judge?
The judge, because he's recognising that whether or not it would make a difference would depend on whether or not.
Yes, I see that, and you're right. That's exactly what he says. But I haven't quite understood what point of Mr. Butler's you're challenging by taking us to this.
Okay, well maybe when I come to Brewster and how it will become clearer. But
No problem. Please do it your own way, but do bear in mind that not just because this is how it's supposed to be done, but for our own clarity of thinking, it's always helpful to know which proposition advanced by Mr. Butler in the last 5 hours you're focusing on, because that's what reply is meant to be about. Yeah.
As I understand
Well,
it, Mr. Logan, the proposition you're focusing on is that there is a clear-cut alternative, and the judge was right to find that there was a clear-cut alternative as part of the proportionality exercise. And you're saying, well, the judge himself recognised that the alternative wasn't clear-cut because it depended on other factors. Is that the point?
And it may not make a difference to the practical position, in which case it becomes a lot less clear-cut. But I think it becomes clearer, and I hope that it will become clearer when we look at Brewster.
Yes, okay.
And the distinction. But as regards Mr. Butler's point about the comparison between housing and childcare. In my respectful submission, none of that really addresses the very deep-rooted and obvious difference between housing and childcare. So references to things like caravan charges or service charges just don't cut it. And again, it's very difficult for the claimant to sustain a submission that's based on housing in some way being akin to childcare in terms of fluctuation, whenever precisely the opposite point is being made again in the evidence by the NGOs that childcare is unlike rent and housing because it fluctuates so much. Again, see page 353, paragraph 1.3. My Lord, as regards how the case was pleaded below and particularised, my learned friend in his grounds set out a number of policy alternatives, which is what I took you to, none of which was ultimately what the judge arrived at in his judgment. And again, it's clear when you look at the totality of the evidence that the different witnesses upon whom reliance is placed all again contend for different outcomes to this problem. So, my Lord, my Lady of Gingerbread contending for a deposit guarantee scheme or a child deposit scheme. You've got Miss Lawson contending for different outcomes as well, paying direct, making improvements to the flexible support fund. You then have the nursery providers contending for direct payment to them. Now the point is, my response to the claimant's case, is that this demonstrates that this is an area classically within the sphere of government judgment and expertise. And you saw that from the decision-making process here. This wasn't a policy outcome worked out by a small number of officials. It was worked out across government and with input from the Treasury, Revenue and Customs and Education. And it was a ministerial decision. It wasn't an official decision.
So what was a ministerial decision?
To opt for a system based on payments that would be paid out in the course of the assessment period.
I think what's been said is, you know what's been said, obviously what you say is formally correct because the Minister mentioned the regulations, but that there is, the evidence suggests, and certainly there is no evidence to the contrary, that the specific issue of whether it was better to have a proof of payment rule as opposed to a proof of liability rule was never referred to the Minister or considered by him.
Well, first of all, we have the record at page 881 to 882 of the meeting at which the options to be arrived at were set out, and it sets out at the second page that ministers were broadly in agreement that the system should be based on costs paid out, save that they were concerned that it wasn't robust enough to stop overclaiming. So that's the first point. The second point, and what all of this seems to turn on then, is the meeting that you have at page 891, where the question is asked, why are you doing cash paid rather than invoicing? And as I've already said, my response to that is, well, that shows when they say that they don't want to have to do reconciliation, that this was a policy which had been worked out, that it was an issue which had been considered.
But it shows it had been considered by officials.
Yes.
Does it show it had been considered by the Minister?
Well, I'm going to come to whether that matters,
right,
because
yes.
my submission doesn't matter. But you know from the documents that follow at page 895, and Miss Parker deals with this at her paragraph 68, that the note was sent to one of the ministers setting out the outcome of that
Sorry, what's the,
meeting.
what page, what, it's Parker, what paragraph
So it's
reference?
paragraph 68 of her statement,
Yeah.
and it's the document at page 895.
Which makes no reference at all to the question that was asked or the answer that was given to it.
No, but my lady, it does go on to discuss, and it does say that concerns were being expressed about upfront payments, about payments always being in arrears, time lags, and the work incentive implications of that. Now, in my submission, that demonstrates clearly that ministers were aware, and it doesn't matter if it's put on, why are you doing invoicing rather than cash paid. The essence or the nub of the concern was actually put to the minister in a more expansive way than the meeting records. My lord, do you want to look at that?
I know we've looked at it already, but it's so central to this particular part of the case that it would be helped, I think, just by being reminded exactly what the evidence shows. I'm trying to find the wretched thing. S2.
Paragraph 5 records the positive response that stakeholders liked the simplicity of reporting paid costs.
No, thank you. I mean, I marked this up heavily during your opening submissions.
6, as expected, and I've already said, my lord, that indicates the minister was already aware of the issue in any event. And then over the...
You say that's not, may not be absolutely as explicit as the question and answer referred to in the minute of the meeting with stakeholders, but it is more than sufficient.
Yes, and it's...
Okay, thank you. It's just useful to be reminded
exactly,
of it.
and I think it goes further than just saying a question was asked, why are we doing this on the basis of cost paid? And as I've already said, one of the solutions that was alluded to was the Flexible Support Fund. You have Miss Parker's description of that at paragraph 70. Now, the issue was also raised about why there wasn't a witness statement from someone saying exactly what discussions they had with the minister about this. This was 10 years ago, so we aren't in the position of the sort of judgment that was made in the last year or a couple of years ago. But in my respectful submission, it doesn't matter. Ministers were aware of the issues that had been raised, and they confirmed the model.
Yeah.
It follows from all of that the distinction between officials and ministers isn't really important here. But in any event, in my submission, that if the court's concerned with the machinery of the executive and a decision-making process, it's not helpful to try and split up who thought about what at one thing, about one thing. And I took you to the case of Tagiri, which you have at tab 14, and what Lord Sumption and Lord Reid said about not actually needing any evidence about the thought processes of ministers or officials. They weren't making any distinction between the two. It's ministers or officials. And in my respectful submission, that just reflects the reality. of decision making within government. So, all of this demonstrates why this is not a case to which Brewster applies, and that the judge was wrong to treat it as though it did. My lord, you've got Brewster, and I just wanted to take you to some bits of it.
Yes.
My learned friend didn't.
Just remind us where it is then.
I haven't, for some reason, made a note of it myself. It's at tab
Tab
16.
16.
16. Thank you.
So before we even get to Brewster, the starting position has to be the position I've already taken you to, Bank Mellet SG position. When you're talking about a statutory instrument, the court has to exercise considerable caution before it will be held to be unlawful. So that's the starting point. Brewster is about a form, whether or not it was right that an individual had to fill in a form to say that their partner was the person who they wanted to nominate for a pension. And at 30, Lord Kerr said that there wasn't really any explanation as to why a form was required, because one of the requirements that was already built into the system were those that went to demonstrating that you were in a genuine and subsisting relationship. So the form was odious, it didn't have any purpose. Now, in terms of consideration, and you get that from 43 as well, it says it doesn't add anything. So when you pick it up at tab 50, what Lord Kerr is talking about in this case is no one was able to advance a reason at the time, or reasons that were contemporaneous, for having this form. And that's why he says at 50 that the discretion can take on a different hue when it becomes clear that a measure is sought to be defended on grounds not present in the mind of the decision maker at the time the decision was taken. So that's what he's addressing. He is addressing true, post hoc. This wasn't thought about at the time, but now that we're thinking about it, there are good reasons. And again, I know that Belfast City Council is trite almost, but again, the position in Belfast City Council, or what it was addressing, was when the decision maker didn't address their mind at all to values or interests that were relevant under the convention. And that might open the door to strike, for the court to strike the balance for itself. And again, 51 and 52 is concerned with post hoc reasoning. Now, I took you to Tagire to demonstrate the restraint that's ordinarily applied in this context. And Lord Kerr had to address why that approach in Tagire didn't apply in the context of Brewster. And he addresses that at paragraph 61. And you might recall of Tagire, it was a case, as I've just said, as Lord Sumption and Lord Reid said, there was no evidence that any minister or official had addressed their mind whatsoever to the problem in Tagire, or the issue. And what Lord Kerr is saying in paragraph 61, the difference is that they had a rationale for the rule in Tagire in any event. So they had an aim in mind. It was a thought-through approach. So in other words, there was a rationale for the rule, even if the decision maker hadn't taken into account the difficulties that might be caused to certain groups of people. Now, we aren't even in, I submit, the Tagire territory, because the issue was addressed in Tagire. My learned friend asked me to make clear, which I think I've already done in my submissions previously, that Lord Reid and Lord Sumption were dissenting, but I took you to the first part of Tagire where Baroness Hale set out the correct approach. And I don't understand that this dissenting part of the judgment in Tagire is controversial, hence why it's being addressed in the context of Brewster in this way.
Yes.
And then at paragraph 64, Lord Kerr goes on to say, in terms of the usual approach, the usual caution or reticence, and you'll see the way he puts it, it's important. So he accepts that decisions on social and economic policy are decision making to which the highest degree of or area of judgment has to be afforded. But what he's saying is where the impact of a particular measure on social and economic matters has not been addressed, the imperative for reticence reduces. But of course here, that's exactly the rationale that was being relied upon. So he's not saying, oh, because you didn't think about or expand upon all of the consequences that this might have, that opens the door to the court to narrow the area of discretion afforded to the decision maker. What he's saying is it's the absence of any rationale at all that opened the door in Brewster in the way that he suggests. And he goes on to say, it wasn't an economic case at the time. The department was not concerned about socio-economic choices when it decided to mimic the nomination requirement. And that is reaffirmed and reinforced at paragraph 65, when he says the fact that it's in an area of social and economic policy doesn't mean that it's immune from review. It's not essential that policy options were clearly in play, but where they were, the cause for reluctance to interfere is increased. That this case couldn't be further from the sort of Brewster situation. And obviously what the court was ultimately concluded at Brewster was the alternative, the less intrusive measure, is that you don't need a form. So in terms of the judge's error in this case, he said, in terms, he was not going to apply a particularly wide margin of discretion because on the basis of Brewster, the issue hadn't been considered, but he got that wrong in my respectful submission. It's quite clear that Brewster is aimed at a completely different point. is where no rationale is advanced at the time for the measure that's in contention. It didn't warrant reducing the area of discretion. And for the same reason, it didn't warrant the judge entering the policy field to say, well, there was an alternative here that may or may not work, that may depend on what the childcare sector does in response. So it doesn't fall within Brewster for that reason either. And my learned friend took you to TP, which I don't ask you to turn up, but it was the same problem in TP. What the court was saying was no evidence was put before the court to assist with whether or not there was a reasonable foundation for the decision that was taken. It wasn't saying, well, the court, the decision maker didn't think enough about it. It was that there wasn't a basis advanced for justifying the rule. And it just comes down to this. Fundamentally, how to pay childcare in a way that meets all of the objectives of the white paper, that meets that, and I don't accept that you can decouple aims and objectives very easily in this context, that has these aims of helping people into work, reducing fraud and error, improving simplicity. That it's open to a court to say, well, I think that ultimately this could have been better done, or this would have been less intrusive if the minister had elected for a liability rule. And a fortiori, given all of the other factors that go into consideration about that, in terms of how you best deal with fraud and error, how you best achieve simplicity, those are matters of expert judgment that classically lie in the decision-making power of a minister. And it's clear from the papers, as you've already seen, that having to reconcile if you were to proceed on a liability basis was of concern. I don't accept that somehow the justification has changed in these proceedings. It's part of the same point. It's reducing fraud and error. I'm going to try and take it at a bit more of a pace now. Can I just very quickly then turn to witty reasons? So again, it is clear if you take paragraph 169 and paragraph 172 of the judgment, the judge reduced the margin of discretion again on the express basis that this was a case where weighty reasons were required. My learned friend now seems to accept that that was risky, by which I assume he means wrong, according to the laws that then stood. And in my submission, it remains wrong because the case of SC makes clear and reinforces that the manifestly without reasonable foundation test is still central. All of the cases, I think, in the schedule that the claimant has handed up, they're all considered in SC. SC is a comprehensive survey of indirect discrimination. And the most one gets at paragraph 103 in respect of that survey are the observations that the European Court has developed into a position of applying weighty reasons in indirect discrimination cases, where it's based on those sorts of stereotypical notions. So things like disadvantaging people on the basis that they work part-time. So my respectful submission, SC does not decide the point that was set out in AM. MA doesn't overrule AM either. The Supreme Court left the question open at paragraph 172 of SC. And the point was made against me that I didn't take this point about indirect discrimination and weighty reasons. The reason it wasn't taken was because obviously the submission on behalf of the Secretary of State at that time to the judge was, you're not applying a test of weighty reasons, you're applying the manifestly without reasonable foundation test. And that was right, as SC makes clear, on the law as it stood. So that's why there wasn't any reliance on AM at first instance.
Well, it's right that manifestly without reasonable foundation was believed to be the test, although what that means has now been explained by Lord Reid, and it wasn't what everybody thought it meant as a result of DH.
Quite so, but at the time of this decision, at first instance, the law as it then stood meant that weighty reasons should not have come into the judge's reasoning. I mean, the line of the cases that are referred to in SC makes that clear. But in my submission, SC doesn't warrant the approach that the judge took in this case. And we say that there are two reasons then why he was wrong to lower the area of discretion. Sorry, not to afford a full area of discretion. Can I then just do the proof very quickly on how the system works? Can I start by saying there's no dispute. Miss Salvato doesn't dispute. Miss W doesn't dispute. You can see that from page 486, 13I, that they are required to produce receipts for their childcare. And if you look at supplementary bundle 1 at page 99, it demonstrates how the system works. So this is the journal, and if you look, I just chose page 99, because I think it's where you most clearly get a demonstration of this. And you can see report childcare costs at 629, 632 provide proof.
Sorry.
Then complete.
Sorry. Yes, I see. Works up the page.
Yes, I do. Sorry.
No,
Yes.
it's fine. Yep. Okay.
And then we can see in her case there was reference to bank statements being provided to verify some of the costs. And then there.
Sorry, I'm not understanding. At 629, when it says report childcare costs,
Yep. Provide proof.
who has written in those words?
I think that those are confirmed by the claimant.
Sorry, no. Someone must have typed in the word report childcare costs.
Yes, I'm going to take you to the prompt system. This is her journal. So as I understand the system, she has reported childcare costs.
So
on
this
that
is, sorry,
date.
629 is her reporting childcare costs, but we don't see that. It doesn't say what they are.
I'm going to take you to
Oh, I see, okay.
the system that she would... This is just her journal. I'm trying to demonstrate the prompts or how you're required to provide.
This is what comes up on the screen when you've got it on the computer.
Yes.
So you log in and you get this box with the dialogue, and then you have to fill it in online.
Yes, and in fact, if you look at the third tab,
In the new thing.
in the new red bundle, so this is actually the screen that you see.
Yeah.
So this is distinct from the journal. So you can see on the first page, reported change, childcare costs.
Sorry, but to go to absolute basics, someone who is registered, or whatever the correct word is, for universal credit has, there's a web page you go to and you log in
Yes.
with your number. This is the sort of thing I just wanted to understand. And you get a menu, and you want to claim childcare costs. So there's a page for report childcare costs. So this is what you go to. You navigate to get to this page. Okay.
So page 2 is the menu. You see childcare costs. in the
So when you say
bottom
page
right.
2, you mean page 3? No.
It's it's paginated at the bottom,
Oh, page 2. Sorry. Yes, I see. That's the original menu. Yeah.
and then childcare costs are in the right-hand column. So if you click on
I'm
that,
sure you're right. Oh, yes, I see. Yep, got it.
then that takes you to the next one. It gives you the warnings.
Yep. Very helpful.
Click next. You'll need to know the dates of your childcare, how much you paid and when.
Yeah.
If we ask for proof of your costs, you must provide it within 1 month or you may not get your money back.
Yeah.
Click to continue. The provider, how much you paid, the date that you paid the invoice.
Sorry.
Maybe
So,
ahead of you.
no, that's fine. I've just been slow. So you click on add a payment, and then how much you paid. Yes, date you paid. Yep. Got it.
Exactly.
Provided, yeah.
And then you get who's attending, who's providing. You have to make your declaration that they're accurate. Your costs have been reported, and then if we need to see proof of your costs, we'll add it to your to-do list,
Yep.
which is where, as I understand it, the journal comes in.
Yes, I see. That's very helpful.
And then you get the prompts.
So what we saw at 629 was her having gone to that page. The journal doesn't show what she's put in. It just reports she's gone to that page. Got it. Okay?
And in that instance, on the 12th of October, some bank statements were provided. So it's the 12th of October. Your reported costs have been verified.
Paid in dollars. Right.
I think that's probably just a typo.
Yeah, I think it must be, yes. Yes, I see. Thank you. So, well, this is helpful. I've now got a much better understanding of how this works. What any particular points
No,
beyond
it's
that?
really just to demonstrate the prompts to provide
No,
proof.
that's been very helpful.
And as I
Thank you.
understand, what the claimant is saying is she has to provide receipts. So
Yep.
insofar as in the submission, we're trying to sort of minimise this system. or making the point that why is a receipt less reliable, you can see that built into the system is, first of all, ensuring your accuracy. So making sure you've set out what it is that you've paid, the dates that you've received it, and then obviously uploading your receipt. And what we say about a receipt is it's not the difference of the type of document between an invoice and a receipt, it's what they show. It's the receipt shows that you've paid. That's
Yes,
what
no, I understand.
In terms of this point about fraud and error, taking you to the vast scale of fraud and error that was inherent in the old scheme, but Ms. Parker also sets out that there is no evidence that there's error to any great extent as well in the new system. So we would say that that demonstrates that it's working as well.
Well, that's what you'd expect if you move from estimated to actual.
Yes. And she also sets out as well, and this is it.
These are all points you made the first time round. I mean, they're not really answers to any point made by Mr. Butler, are they?
I'll move on then to indirect discrimination, if I may. It appears to be common ground that there is no statistical basis upon which the claimant can demonstrate that the way that childcare is paid is causing difficulty, and difficulty in that context must mean that it is stopping people getting into work or causing them to leave work. Still less is between men and women.
Well, as you say, I think that is a point that we, Mr. Butler acknowledged, but he said that the evidence does, there's no statistical basis in the sense of none of the statistics directly prove it, but there is indirect evidence that is sufficient, of exactly the kind that the judge relied on and explained.
Yes, so essentially just coming down to the differential in the pay and the possible wider evidence of what was being said by NGOs as well, although that isn't quantified in any way either. So I just wanted to deal with this point about just taking a base comparison.
Sorry, taking a what comparison?
A base comparison between the earnings of single men against single women. And just to first make the point that, again, that's not straightforward in the context of universal credit, because Regulation 22 applies a taper. So you're allowed to earn your first £293, not tapered. And after that, a 63% rate is applied.
It would save time if this isn't a point in your skeleton argument, is it?
No, but I just wanted to address.
No, okay. No, I just wanted, if it was, I would just.
No.
Okay.
So obviously, the more a greater earning, 63% of a greater wage, greater earnings, is more. It's just coming back to the point that under universal credit, the lower earning person is able to keep more of what they earn.
Yes, but not
And
not totally.
No, not totally, but that participation tax rate that I took you to in the white paper does apply, but it makes it clear that just basing the calculation on a simple differential of £5 between earnings doesn't take into account that it is more complicated under universal credit because of the progressive tax rate, and that the person earning less will, as it were, come out better under universal credit.
I see the time. How much longer do you expect to be? You've had an hour for reply, which would normally be ample.
you were willing to sit on, I should be able to finish in 10 minutes or so.
Yes. 10 minutes.
But we come back to the point in any event that, and I think, my lord, you have the point, that all of the issues that go into whether or not a lower earning person can make an upfront payment are many and varied. Some of them might be linked to the resources. But again, there are other factors that will all feed into that. So, for example, does the person get the 30-hour free childcare? Have they had recourse to a flexible support fund? How much childcare do they actually need at a given time? In my respectful submission, once the person is in the system, then obviously it becomes much, much harder to work out any differential impact thereafter. I entirely accept there are peaks and troughs, but the peaks and troughs go in different directions depending on the individual circumstances of the person. So it's not just about resources, there are other factors that feed into that. Which is again why we say that sort of, I don't want to say simplistic, but just basing it on that. Crude is not quite the right word, but just taking it on the basis of that base differential doesn't accurately convey the position. And again, I mean, given that the employment rate of lone carers has gone up, I think it's 12 percentage points, there is no evidence of a structural issue. In that regard either. And overall, there isn't any authority that a measure can be discriminatory on the basis that one group has less resources available to it. And the case law tends to be to contrary effect in terms of Adiatu, planned motherhood, and delve. And I accept that there may be a difference because those cases are concerned with getting a benefit, so to speak. And I also accept that the case of Williams was concerned with impecuniosity as a status,
Yeah.
but nonetheless, the same issues that went to status can also be relevant to the discrimination alleged as well, or whether or not there's indirect discrimination. The problem of relative resources I do want to go back, I think you have the reference as well, that paragraph 149 of Adiatu is also helpful on that point. But my Lords, my Lady, I think there must also be a principled issue here as well, as to whether or not that line of reasoning means that any measure that requires a fee to be paid is potentially indirectly discriminatory to any group of people. Can I just finish off then on the Johnson point?
Sorry, the what point?
The Johnson point.
Yes.
The judge here found that there were striking parallels between this case and Johnson on the facts, and that's an approach that my learned friend is now distancing himself from. I'm trying to make it more about whether or not the rulemaking power was exercised in a proportionate way, but that was not the way the challenge was brought. It was brought squarely on the basis that Johnson was applicable on the facts to this case. And my respectful submission, when at SC, the Supreme Court talks about a commonality of approach, it's not reducing the high hurdle for a rationality challenge, because it sets out the classical exposition for a rationality challenge. What it's indicating is that equally there's a high hurdle when it comes to the manifestly without reasonable foundation test. My respectful submission, it doesn't help my learned friend's submission to just cherry pick out bits of Johnson, because ultimately Johnson was about a decision not to fine-tune a problem in the face of evidence that it was causing real loss, and potentially 85,000 people were in the same position. And again, the idea that that the aims of the white paper and the aims of universal credit can be distilled into making work pay, it's not making work pay at any cost. The Act had other aims, and it's simplistic to suggest that trying to balance out those aims, that it can somehow be equated ultimately what happened in Johnson. Johnson just doesn't apply to this sort of case. And it appears to me that the Court of Appeal was going out of its way to make it clear that it turned on its facts. Apparently I got the regulations for housing wrong, and that the correct reference should have been Schedule 4, paragraph 6.4.
Thank you.
Unless I can assist you with anything further.
Thank you very much. Well, obviously you will be aware that we will be reserving our judgments. This will require careful thought. We're aware that the sooner there's a decision, the better. That's indeed one reason why the case came on comparatively quickly. But there's a lot to think about. And there is the vacation, though that doesn't mean we won't be working. So I don't think you can expect a decision very soon, but it will be as soon as we can possibly make it. The usual procedures about circulation of judgment in draft will be followed. I think with two such experienced counsel, I need to spell out what those are. It remains to thank both counsel and, in this case, more I suspect than most, the teams behind them for the careful and well-informed submissions that we've received.
My Lord, I'm sure on behalf of everyone, can we thank the court and its staff for convening a hearing in person as well. it's obviously a good deal easier doing these kind of cases.
It is a lot easier. In fact, I don't think there's anything exceptional. That is what we have been doing for a little while. But it is better.
Nonetheless.